If I told you that men get charged, tried, and sent to jail when they are factually guilty of injuriously harming a woman or child, what would you think? If I told you that men get charged, tried, and sent to jail when there is no proof a crime even took place, what would you think? Well, let's look at two common assumptions that will help you understand how a continuous stream of injustice can be carried out against an innocent man, from accusation to jail time to a lifetime of persecution. Assumption number 1. It is the job of the police to investigate a claim thoroughly. If there was no evidence of a crime, the police wouldn't have a reason to charge the man. Firstly, statements equal evidence. In our system, a complainant's statement has as much weight as any other form of evidence and can stand on its own as prosecutorial evidence. Second, some police will only investigate with the victim, otherwise known as a victim-led investigation. These investigations only look for inculpatory evidence, that is, evidence that can establish guilt. Dirt will be dug up on the accused and can be admissible as evidence against his credibility and reliability, regardless of relevance to the issue at hand. A statement that the woman fears for her safety constitutes as sufficient evidence for a suspect to be arrested and charged. Third, victim-led investigations do not look for exculpatory evidence, which is evidence that can exonerate or establish innocence. Some police choose to ignore this type of evidence as it can be perceived as an investigation into the woman's credibility and reliability, which women's rights groups advocate to be unfair to the victim. Some police will only take statements from other witnesses who are likely to give only inculpatory evidence. There are victim protection laws and policies in place based on unproven stereotypes that effectively eliminate the requirement for police to investigate the woman for potentially exculpatory evidence. Criminal Code sections 274 through 278.1 illustrate this. Section 274 removes the requirement for corroboration. Basically, that means no other witness statements are required to back up the woman's claim. No other evidence of any kind is needed to back up the woman's claim. Section 275 removes the recent complaint limitation. What that means is there is no statute of limitations on making such a claim. A 40-year-old woman can claim that 30 years ago she was abused by a stepfather, for example, and this cannot be used as a defense. The fact that it took her 30 years to come forward and make a complaint, that cannot be used as a defense by the accused. Section 276 removes the admissibility for evidence relating to the past sexual behavior, unless a court order allows it, and of which comes with an extensive list of conditional criteria, virtually prohibiting the usefulness of the outcome. The history of this particular one revolves around a particular case of a woman who was a prostitute who made a claim of rape, and the defense used the fact that she had a past sexual history being a prostitute, that she couldn't legitimately claim rape because of such a thing. So that case set this precedent moving forward, which is used today across all cases. It is not applied only to prostitutes. It is applied to every woman who makes this claim. Section 277 removes the admissibility of sexual reputation. That basically closes any loophole a defense would try to use to get around 276. Section 278.1 removes the right to produce to the accused third-party records of the complainant, including medical, psychiatric, therapeutic, counseling, education, employment, child welfare, adoption and social service records, personal journals and diaries, and records containing personal information, if that's not broad enough for you, unless again a court order allows it, and of which comes with an extensive list of conditional criteria virtually prohibiting the usefulness of the outcome. Also, the judge can review this evidence first before ruling on its admissibility. Also, to help you understand this a bit more, when it says it removes the right to produce to the accused third-party records of the complainant, what that means is, in any case, the Crown is obligated by law to produce all disclosure to the defense attorney and the defense team in order to build their case. This is the exception because these are deemed an attack on the accuser's reliability and credibility for the defense to freely be able to have access to these records and use them to build their case against her story. So what this means is not all disclosure is by law available to the defense. In this case, in the case of basically any type of third-party record relating to the complainant, you have to go in front of a judge and get a court order to have those records released, but you have to know exactly what it is that you're looking for. You can't just tell the judge that I'm pretty sure there's going to be something in that record that will help our case. That is a condition of which you cannot win a ruling. So it's very extremely unfair to the accused, because essentially you have to know what you basically have to know exactly what it is you're looking for, and how is that even possible when you are an innocent man and you are suddenly broadsided by this accusation and you're being dragged through the system, and the last thing you're going to know is exactly what to look for in a third-party record. It's impossible. That is a very rare occasion on which that would happen. And it also depends on the judge. It depends greatly on the judge themselves and the flexibility that they allow in ruling on the admissibility. Okay, moving on. Assumption number 2. Crimes of a sexual nature often happen with no witnesses, so when a woman claims she was raped or sexually assaulted, she should be believed. Why would she lie and go through all the trouble of a trial? Well, firstly, this is just a flawed assumption overall. There are a myriad of cases where the woman has recanted or has been proven to not be telling the truth to some degree, also known as perjury. However, our system generally does not punish this type of crime for fear of discouraging victims to come forward. Therefore, any discouragement from lying is removed. Motivators and reasons to fabricate include 1. Mental illness, insecurity issues, and attention seeking. 2. Free money from the Criminal Injury Compensation Board. It does not require a police charge or a conviction to get this money. 3. Lifetime disability benefits as a result of diagnosed PTSD due to the alleged assault. No requirement to work for a living. 4. Alibi for another wrong committed, or fear of losing the support of someone deemed too important to lose. 5. External influences such as a therapist practicing memory recovery techniques, and yes, this still happens today. Journalists who want to sensationalize a story. A social worker meddling in family affairs. A well-meaning peer who just wants to help a damsel in distress. And last, revenge. Justification to gain support and or eject someone from their life. Women's rights advocates, feminist judges, and feminist politicians have already successfully created laws that deem any police investigating or defense cross-examination questioning of topics listed above to be considered an unfair attack on the accuser's credibility and reliability, also referred to as victim blaming. So as I've done here, I've put two things side by side. One, the motivators and reasons to fabricate a story, and two, the sections of the criminal code that I described earlier that strip a man of a defense. So let's take, for example, mental illness. Let's say the accuser has a history of mental illness. Let's say the accuser is saying that they take so many drugs, there's no way that they're telling the truth, they're delusional, there's all kinds of reasons why they would tell a story through their mental illness. And the Crown and feminists, particularly historically, have managed to successfully create a stereotype argument with this by basically saying that people with mental illness are more likely to be sexually abused, which there's no proof to prove that. The other way to look at that, the flip side of that coin, is that people with mental illness are more likely to fabricate stories. However, it is embedded in our criminal code to support that stereotype that the feminists have created and beat into our psyches. So we don't question that. Well, it's a proven fact, though, that these are also causes of telling delusional stories, whether they believe them to be true or not. The fact is, from the perspective of a man who's innocent, to them that would be the only reason why they would tell this story. And yet they are blocked from having those records produced into the case, or even to a police officer at the investigation phase, to exonerate them.